What will the jury think if an attorney fails to live up to his promise that he made during opening arguments at trial? You want to know what this is about and why it's important as you're contemplating bringing a lawsuit for your own injuries? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. In a trial involving an accident matter or medical malpractice or wrongful death, at the beginning of the case, an attorney will make opening remarks. And now, typically, a plaintiff's attorney, the attorney who represents the injured victim, now is going to tell the jury what the case involves. And during the course of his opening remarks, he will often make certain promises. Ladies and gentlemen, you're going to hear Dr. Jones come in and testify as our expert. And he's going to show you that the doctor violated the basic standards of medical care. And now he's going to tell him about other promises he probably will make about the damages, about causation, showing the link between the wrongdoing and the injuries. And now at the end of the case, during closing arguments, the attorney has an opportunity to explain to the jury again how his promises that he made in opening arguments now have been proven by the testimony, by the evidence that's come in during the course of trial. But what happens, though, if the attorney has been unable to prove certain points or promises that he made at the beginning of his case? Is it going to hurt his case? Is it going to destroy his credibility? What will the jury do? The reality is, if it's an important point, the jury will likely hold it against him and his client. Because an attorney who makes certain promises at the beginning of the case, who cannot live up to them, guess what? The defense attorney is going to jump on that because he's taking very careful notes about what the attorney is promising during opening arguments. And now at the end of the case, if he's been unable to prove those particular points, the defense attorney will be the first one to jump all over that and to argue to the jury, ladies and gentlemen, Mr. Oginski has been unable to prove to you the following promises that he made: that the doctor violated the basic standards of medical care and that wrongdoing was a cause of this person's injuries. And because of that, there's absolutely no way you can give his client a verdict in his favor. You should know that in New York, when an injured victim brings a lawsuit seeking compensation for all the harms and losses that they suffered, their credibility is the most important thing for the jury to consider and evaluate. And if the attorney breaches that trust, breaches that credibility, now the jury in all likelihood is going to take it out against the attorney and his client. So why do I share this quick information with you about how important it is to keep promises that are made at the beginning of the case in order to successfully show that you're entitled to a verdict in your favor? Because in all likelihood, I recognize you have questions of your own, and you're contemplating bringing a lawsuit, and before you decide to go ahead with a lawsuit, you want your questions answered. You know, I answer questions like yours every single day, and I'd love the opportunity to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.